A wedding day is a celebration of love, surrounded by friends, family, and promises of a shared future. But in the eyes of the state, none of that emotion guarantees your partnership actually exists. Entering into a marriage or a civil partnership requires achieving strict legal validity. It is a state-sanctioned formation, completely separate from the ceremony itself. If you fail to follow the strict rules of formation, you risk falling into what the courts call a non-marriage or a non-qualifying ceremony. This is an event so legally flawed that the state views it as completely meaningless. The consequences are severe. If a non-marriage breaks down, the partners cannot apply for the financial or property orders normally granted in a divorce. The family courts close their doors, and you are left with zero statutory protection. You can spend a lifetime with someone, building a home and a family, but without exact state validation, that emotional commitment provides absolutely no legal shield. Escaping the non-marriage trap requires successfully navigating a strict state-mandated procedural gauntlet. Analytically, look at the sworn declaration from 1924. It shows exactly how rigidly the state has always tracked and verified the rules of relationship formation. The document lays out the exact written conditions required to prove legal validity. The individuals had to declare their age and swear an oath confirming the absence of any lawful objection or impediment to the union. We no longer write these declarations on parchment, but the state's absolute demand for procedural accuracy and proper documentation remains identical today. Securing modern financial and property rights upon the breakdown of a relationship hinges entirely on proving you executed this legal checklist flawlessly. This decision tree outlines the first non-negotiable step of the legal gauntlet: capacity. These are the foundational legal traits a couple must possess before a ceremony can even legally begin. First, the minimum age requirement. Under a 2022 law that took effect in 2023, 16 and 17-year-olds can no longer marry in England and Wales. The legal minimum is strictly 18. Second, you cannot marry someone within the prohibited degrees of familial relationship, either by blood or by marriage. Finally, the parties must have capacity under the law of their country of domicile, and there is an absolute prohibition on bigamy. You cannot be already married or in a civil partnership at the time of the ceremony. Failing any of these capacity prerequisites renders the relationship void. Unlike a non-marriage, a void marriage allows for some financial claims, but in the eyes of the law, the union itself never validly existed. Capacity is the unforgiving baseline of family law. Without it, no amount of celebration can forge a legally binding partnership. Once capacity is established, you enter the second step of the gauntlet, the formalities. These rules dictate the specific execution of the legal union. The process begins with the civil preliminaries. Couples are legally required to give a formal notice of marriage at their district registry office, declaring their intention to marry at least 28 days before the ceremony. For decades, civil ceremonies were bound by a strict geographical constraint. To be legally valid, they had to be conducted inside designated approved premises with a fixed roof. The rules governing these locations underwent a massive modernization with the Marriages and Civil Partnerships Regulations 2022. Following a public consultation, these 2022 regulations permanently altered the formalities, finally allowing civil marriages and civil partnerships to be legally binding when conducted outdoors within the grounds of approved premises. This amendment proves the state is capable of stretching its rigid formal boundaries to accommodate modern society as long as the strictness of legal registration is maintained. Successfully completing this legal gauntlet yields significant rewards. It unlocks the full suite of financial protections, property rights, and inheritance rules designed to support spouses and civil partners. Compare that safety to the danger of purely religious ceremonies, like the one shown in this photograph. If a couple undergoes a religious marriage but fails to give proper civil notice or register the union with the state, they plunge straight back into non-marriage status, totally unprotected by the courts. Family law is a moving target. The Law Commission's 2022 report on celebrating marriage proposed a new weddings law aimed at further simplifying these exact formation processes and expanding where couples can legally wed. Because the state's definition of a valid formation continually evolves, individuals have to ensure their partnerships match the current legal requirements to remain protected. The wedding day is the emotional celebration you share with your community. The formation is the essential legal armor you build with the state. The physical location, whether an ancient cathedral, a registry office, or a newly approved outdoor space, does not grant validity on its own. Procedural compliance does. Ignoring the rules of formation leaves you exposed to extreme financial danger. If the relationship ends, you walk away with only what strict property law allows, completely shut out of the family court system. Strict adherence to the legal formalities of formation is the only way to guarantee your partnership is recognized. In the eyes of the law, romance is irrelevant. Procedural perfection is the only thing that secures your financial and legal future.